Oh, yay, oh, yay, oh, yay. The Honorable Tennessee Court of Appeals is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. We appreciate you being here. I know that everybody just wants to be in the Court of Appeals all the time. Y'all can laugh, it's okay. I want to take just a few moments before we call the first case and run over the procedural groundwork before we get started. Obviously, I've got experienced practitioners here. They know what's going on, but I always feel better just giving a little refresher course before we get started. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but the way to do that is once you come up to the podium and before you begin your argument and after you've introduced yourself, you can request that 5 minutes. Obviously, appellee gets no rebuttal time. We have a lighting system that hopefully is beneficial to the parties. It's, the monitor is on the podium. 3 lights, green, yellow, and red. As long as the light's green, you got plenty of time in your argument. Once the light turns yellow, it means you're running out of time, and once the light turns red, you're out of time. We ask that you please respect those time constraints. Obviously, if you're answering a judge's question, feel free to continue, and we can modify that as we go. One very, very important thing for those folks making the argument to know. These arguments are being live streamed. The important thing about live streaming is this. Once you say it, it's out there. So keep that in mind. We can't have do-overs here as far as the live streaming. So think about what you're going to say before you say it, because we can't do anything about that. Ms. Angie, anything we need to take up before we call the first case? I also want to introduce your panel for this morning before we get started. Have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. You may call the first case, please.
Sandra Easley versus City of Memphis.
Good morning.
Good morning.
Horse. My name, for the record, excuse me.
There's water back there.
I'm going to have to get a sip, I guess, with sinus. For the record, my name is Dale Tuttle. I am here on behalf of the City of Memphis as a City of Memphis staff counsel. This is a personal injury case wherein it was tried pursuant to the Governmental Tort Liability Act.
Before you get started, you want your rebuttal time?
Thank you. 3 minutes. I've got the note right here, and I didn't even follow through.
Well,
thank you.
That happens quite often.
That's what Post-its are supposed to be for. The court, at the conclusion of the proof, found that Paul Haney, a driver for the City of Memphis, going on 10 years now, record reflects he was hired in 2014, was 90% at fault for the plaintiff's alleged injuries when she crossed the street outside of a crosswalk. She was charged. She went to court. and she admitted that she was at fault. The plaintiff missed 5 days of work in 2017, never went back to a doctor. I believe she's here today. And the court awarded $106,000. The court found that Mr. Haney was 90% at fault, and the self-confessed pedestrian who admitted crossing outside the crosswalk was 10%. Now, the court found Mr. Haney was on his cell phone. He denied it. She found it. For the purposes of today, it is what it is. But it's the city's position that the preponderance of the evidence, certainly the greater convincing effect, is such that a best case scenario for the plaintiff would be 50-50, a dog fall, or more appropriately, more like 90%, as Judge Crawford, Frank Crawford, affirmed in the Norman Prather case, cited at page 10 of plaintiff's brief, a case that the plaintiff calls exceptionally similar. Well, I would concur. Not only did that jury put 90%, trier of fact, on the pedestrian crossing Central Avenue right over in Midtown, Memphis, they even awarded the defendant some property damages. Now, we've got a driver who the court found was using a cell phone. We denied. Let's go back to the prequel. Let's go back to the beginning. What's the greater convincing effect of the preponderance of the evidence? At the risk of getting shot, I'm going to show this Exhibit 6. It is a marked crosswalk, handicapped accessible, installed by the city of Memphis at who knows how much expense. That is a safe harbor for pedestrians to cross. Exhibit 2, in the record, shows where the plaintiff was. 40 feet, about the distance from me to that sheriff deputy out front.
I want to make sure I understand your argument. Are you saying as a matter of law that the fault cannot be as the trial court said because it was a crosswalk? Or are you asking us to find that the court erred in allocating that fault? And if so, how do you do that?
I believe the court erred in allocating that fault because I would submit that reasonable minds cannot differ, but that one who fails to yield in violation of a statute and who further consciously and willfully puts themselves in a place of peril from which they later become injured cannot, as a matter of law, be guilty of less than 50% fault. Whatever.
Any law on that?
There is the Cryer versus case that I cited in my brief that I would submit is analogous to this case. We have absolute admitted fault on the part of the plaintiff. It's undisputed. We have a situation.
When you say that, are you saying that the plaintiff admitted to crossing outside the crosswalk?
Yes.
Or are you saying the plaintiff said, it's my fault?
Plaintiff admitted she violated the statute, which is negligence per se. She admitted that had she stayed on the sidewalk, she wouldn't have been hit. And that, I submit, as a matter of law, has to be not less than 50%. That is the position of the city, regardless of the fact that the driver denies that he was on the cell phone. This event, he was where he had a lawful right to be, and the plaintiff intentionally and willfully violated what is statutorily prohibited and did not exercise reasonable care in utilizing what they had available right there, designed specifically for the citizens of Memphis to safely cross traffic. And the city submits, I would respectively submit, that that cannot be less than 50%. I'm watching my time here, but I want to be sure I've answered to the best I can your question. Judge Stack?
Go ahead.
Now, we also have a finding that the city was guilty of negligent hiring and negligent retention. There's no proof.
Is that even an issue for this case?
It is, because the court awarded it. And we denied it, and we've appealed it on the basis that there is no proof that the city didn't do anything to check him out. There's no proof of any negligence on the part of the city's hiring and retention. There's no proof. The plaintiff has the burden of proving that cause of action. The case they cite stands for award.
Well, that's where I was attempting to get to, is how was this award allocated?
It just came down as future pain and suffering, present pain and suffering. It was verbatim, cut and paste from plaintiff's complaint. That's how it was allocated. And there's no evidence of current medical expenses, much less future medical expenses. None.
Any restrictions?
None. She missed 5 days of work.
Was there any permanent impairment awarded?
No, sir. No, sir. No impairment. The court found that she had a long and arduous treatment to recover. That's what the court found. What the plaintiffs testified to, I was off 1 week with no pay. Question, other than the 5 days, the period you're talking about, you haven't missed any periods of work for any reason related to this accident. No, sir. 5 days, $106,000. That's $16,000 a day. And if you extrapolate it out to a year, it's over $6,400,000. I believe the preponderance of the evidence, with greater convincing effect, shows that that award is not reasonable. She missed 5 days of work. Further, in support of their claim, they had one paid expert. There's no need to name him here now. $65,000. This expert has been paid by plaintiff's law firm. It took months, as the record reflects, to pull that information out of the then plaintiff's counsel. But I got it. Charged $5,000 for his deposition, never saw the plaintiff, never read the deposition, gave a history of Mr. Haney running her over on the sidewalk. That's a deposition. He did not testify by telephone. He did not testify live. What difference does that make? As your honors all well know, this court can determine the weight and credibility to be given that deposition, if any. I submit, one, the evidence ponderates against an award of $106,000, and that the finding of fault is in error.
Let me ask you this, Mr. Tucker.
Yes, sir.
We talk about the damages for a minute. Apparently there was over $22,000 in medical damages that were awarded. What amount of those damages were ordered, or medical tests were ordered by a treating doctor?
There was no treating doctor. The treating doctor prescribed Tylenol. That's it. Oh, wait, I take that back. Ibuprofen too. She went to the emergency room twice. That was it. Thereafter, the only treatment was that referred, according to her, through her lawyer. And the record reflects the name of the lawyer and his cell phone. There were multiple diagnostic tests, Your Honor. MRI, CAT scan, you name it. She was even sent by an Uber to Jonesboro. That's in the record, but it didn't come in trial. Every single test negative. In her actions, support the findings of the test. She's back at work in 5 days, caring for elderly people.
So how much of that 22,000 was not ordered by a treating doctor?
I'd have to break it down. There was a lot of physical therapy. It's in the, I do not have the numbers. The medicals from the emergency room, I believe to be approximately 6,000. The rest were ordered by a nurse practitioner or somebody that, the plaintiff's law firm is how she described it.
Was the physical therapy ordered by a treating doctor?
No.
Was the physical therapy ordered by a nurse practitioner or someone like that?
Yes. The lawyer
Was
referral.
this a person who was treating the plaintiff?
Well, I don't know that you would, that's, I guess, a term of art. It depends on where you're standing when you use that word treating. She received physical therapy at the recommendation of her law firm, and that's according to her. I'll leave it at that.
What does the record show?
That, just what she said, that she went to this nurse practitioner or whoever the plaintiff's law firm uses, not unlike the expert, the $65,000 man, and they prescribed the physical therapy. And all the time, she was working, caring for elderly. She couldn't be, it wasn't a long and arduous journey. But $22,000 were medicals, approximately 6 were emergency room bills. That I don't quibble with. I quibble with liability, but not those bills.
There was no testimony from any treating medical person?
No, sir.
Other than the expert who was not a treating doctor?
No, sir. No testimony other than, as you said, the individual who never read her deposition, never met her, never treated her. That's the only medical, in quotes, proof presented.
So
And the court,
he didn't perform an independent medical exam on her?
no, sir, he did not. He did not. He took the records with the understanding, the most important thing for a physician is a starting point, as we all know, the history, and he didn't even have the history right. Had us running her down on the sidewalk. For $5,000, you'd have thought you'd at least get an interview or look at the deposition, but that's an aside, and I
Are
just...
the medical records from Methodist Hospital where she would have given a history, is that in the record?
I believe that to be in the records, and I think they're accurate. Yes,
They are in the record.
I believe they are. They're an exhibit to his deposition, which was exhibited at trial.
The medical records from Methodist Hospital?
They should be in the record along with all of the records exhibited to his deposition, and I've got a box over there if need be.
I'm not sure they are, so you may want to check that.
Well, the plaintiff made them an exhibit. As to whether they made it here, that's another story. I'm not sure. In summation, again,
You've used your time.
it shows 126, I'm sorry.
126 the other way.
You're right, I'm done. Do I have 2 minutes left anyway?
You've got your rebuttal time, yes.
All right, thank you. Thank y'all.
You were answering questions.
Thank you.
Thank you. We'll hear from the appellee.
May it please the court. Mary Elizabeth Sanford, attorney with Reeves Law Firm, on behalf of the appellee Sandra Easley. We are asking that the Court of Appeals affirm the trial court's judgment in its entirety, which was in favor of the plaintiff. The appellant has presented to you today a number of issues. There were 8 issues in his brief, but those issues really boil down to this: whether the plaintiff met her burden of proof of negligence against the city of Memphis by a preponderance of the evidence to support a finding of 10% fault on plaintiff, 90% fault on the defendant, and an award of $106,580.06. And then whether plaintiff's medical expert was properly admitted by the trial court judge. As you're all aware, this was a bench trial. And so the standard of review for the judge's findings of facts, along with comparative fault, is de novo, with the presumption of correctness unless the evidence preponderates otherwise. And then for conclusion of law is de novo with no presumption of correctness. So starting with the first issue, which is plaintiff's burden of proof of negligence against the city of Memphis, the trial court judge had the opportunity to see and hear the testimony of both Mrs. Easley and Mr. Haney, and she wound up resolving their conflicting testimony and discrepancies favorably to that of Ms. Easley.
Ms. Sandra, let me ask you a question. I'm trying to understand the facts of this case. There's no dispute that your client did not cross in the crosswalk, is that correct?
Yes, and if I could paint a better picture for you, I have those same exhibits.
I want you to answer my question.
Okay.
So there's no dispute about that?
There's no dispute that she did not cross in the crosswalk.
And as I understand it, Mr. Haney's truck was third in line behind two other vehicles. No dispute about that?
No dispute, and it was stopped.
And it was stopped because of a red light facing west towards the river, is that right?
Yes, his testimony is that it was stopped because of a red light, and my client's testimony is that his vehicle stopped as well, and that is why she decided to cross.
And she went between, when she stepped off the sidewalk, she was attempting to cross between two vehicles, in other words, between Mr. Haney's vehicle and a vehicle that was in front of Mr. Haney, all of whom were allegedly stopped at a red light.
Yes, that's correct.
And the light changed to green. And that's why Mr. Haney's vehicle began to move?
No, so at the proof at trial is that our client, she observed what was in front of her. There was a vehicle stopped closest to the curb lane where she was, Mr. Haney's vehicle, and another vehicle beside his lane in the middle lane stopped as well. There were a group of people in front of her that had already crossed the street, and that is why she decided to cross. These vehicles were stopped. She didn't just jump into moving traffic.
Well, my question is, Mr. Haney testified is that the light changed, he took his foot off the gas, and his truck began to move, and your client walked into his truck as it began to move. Is that?
And that's where the issue is. The judge was able to evaluate the credibility of the witness and came to the conclusion that our client didn't just walk into his truck. The vehicles were stopped. And
Well,
Mr. Haney,
obviously his vehicle was not stopped when your client walked in front of it because it was moving, wasn't it?
well, it was stopped. That's the reason that she stepped off the curb. So when appellant says that there's this admission that if she hadn't stepped off the curb, there would be no accident, you know, that's just a distraction. That's like anybody saying, well, if I didn't get in my car today, I wouldn't have had an accident. The issue is no vehicles were moving. The vehicles were stopped. There was a group of people that went ahead in front of her. She was lagging behind the group.
While the light was red, those people crossed in between the vehicles. But when your client stepped off, the light changed, and that's why Mr. Haney's vehicle began to move.
But if Mr. Haney and
What other reason would he have begun to move?
well, and that's the issue. Even if the light turned green, if he was using due care and had a proper observation of what was in front of him.
About whether the light was red or green.
Can you say that one more time?
Question about whether the light was red or green.
I believe that there is a question because
Well, no. Was there a dispute in the evidence about whether the light was red or green?
my client is testifying that the light was red. Ms. Easley is testifying that the light was red when she was crossing.
Okay,
So
all right,
that is what she is testifying to.
okay.
But Mr. Haney was stopped behind another vehicle. He wasn't the first vehicle in that lane.
No, he was not.
He was the third vehicle.
Correct.
And when your client stepped off the sidewalk in front of his vehicle is when he began to move.
That's what Mr. Haney says. But then he also says she walked into, he says that Ms. Easley walked into.
Let me, hold on just a second. Mm-hmm. Logically, how could both be? What you're telling me is there's no question that Mr. Haney, or whoever the driver is, was the third vehicle. The light, your client says the light was red, he says the light was green. but he was the third vehicle. So how could he have impacted your client if the light wasn't green, unless the first two vehicles actually ran the light?
And that would be logic, Judge Stafford. The issue is, even with the light being green, even if there's no dispute as the light being green, when she stepped off the curb, she's asserting that the vehicles were stopped to let individuals cross. There was a group in front of her, and she was behind them. And so Mr. Haney had the duty to operate his vehicle with due care. If he saw her, he would have been able to press the brakes in time to not hit her. She didn't just walk into his truck.
What I'm trying to determine is what facts the trial court found. And one of the things that we have to consider in reviewing the facts is if those facts are illogical or can't be that way, then we have to question the decision made by the trial court. So when you say my question going to where the vehicle was and whether the light was green or red, it seems illogical and quite difficult to get to that point. So, yeah, I agree with you. Even if somebody steps out in front of you, you've got a duty to try to stop. But we're not there yet.
Right. And I would say that, there was not anything from my client. I believe that she, in fact, admitted that the light was green. But, her position is that...
She said the light was red.
Right, and that's why, but when you say it's illogical for the light to be red and on her hand and green on the other hand, what I'm saying is that she's doing what a normal person would do. She sees these vehicles stop, she sees the people in front of her cross. Even if he had the green light, he had the duty to operate his vehicle in a safe manner. He admits he saw her. He admits he saw her on the curb. And so if he was in fact paying attention and, utilizing his vehicle in a safe manner, he would not have hit her, is our position.
That brings me to another question. There's testimony as I understand it, there's testimony in the record about the driver being on the phone,
Yes.
being distracted.
Yes.
And then there's testimony, as I understand it, subsequent testimony from your client that said, I didn't see him. Is that accurate?
No, the testimony has always been that she saw him in his vehicle, she saw him stopped, and at the time of the incident, she saw him on his phone. And so that has...
She specifically saw him on the phone?
Yes.
Okay.
Yes. And so...
Let me ask you this. As I understand it, she was struck by the right side of the vehicle where the right headlight. Is that accurate? In other words, struck her on her left side?
On her left side to make her fall on her right side.
With the right headlight area. Is that correct?
Yes, it would have been the right front of his truck.
So in other words, basically, she stepped off the curb and was immediately struck by the right headlight of his truck.
Yes, when she stepped off the curb, she was knocked to the pavement by the right front of his truck on her left side and fell on her right side. And so when determining whether an individual has conformed to the reasonable care standard, the trier of fact must consider the evidence presenting regarding the facts of the case and may rely on, like you said, logic, common sense, public policy, and precedent. And that's what the trial court judge did here. And again, she weighed the testimony in her bench trial.
Where did the testimony conflict?
Our client is saying that there was a group of people in front of her that were allowed to cross between those stopped vehicles and that she was following behind and that is the reason she crossed the street. Of course, Mr. Haney is saying that he never saw any group of people cross in front of him and he only thought she was on the curb and proceeded to. For the most part, as far as the description of the events that happened, that's where the testimony conflicts.
Okay.
And as far as allocation of comparative fault, again, the trial court ruled that because our client, Ms. Easley, was not in a crosswalk, that 10% of fault should be attributed to her, and then 90% of fault should be attributed to the city of Memphis for failure to maintain due care, for being on his cell phone, and for reckless driving. And so
What was the reckless driving?
just not paying attention to someone standing on the curb and whether that person, is about to cross the street. You say you saw the person, that's where the reckless driving comes in, and then being on your phone. He obviously wasn't paying attention, because if he was, he wouldn't have hit her. We wouldn't be here today. And so
What was the proof of the city's negligent hiring and retention of Mr. Haney?
for negligent hiring and retention, I believe you said it best. That's not the biggest, the issue here, but our proof was that he was.
Is it an issue?
Based on her ruling, the damages were for negligence against the city of Memphis. And so I would say that.
Well, she found, the judge actually found that there was negligent hiring and retention, didn't it?
Yes, she did find that, and we would submit that it was admitted Mr. Haney was a city of Memphis employee, and that the testimony showed that Mr. Haney was on his phone, he was distracted, he wasn't paying attention, and so that would, hold a claim for negligent supervision, and that's why the judge found that.
Did the judge have any input in the drafting of the order that she signed?
Yes, I believe so. Are you talking about the
judgment? Did the judge draft the judgment, or did your law firm draft the
So,
judgment?
I believe she has some input in it, but I was not the attorney of record at that time, so I'm not 100% certain on that. I became the attorney of record after the trial.
So you don't know?
I don't know.
And there was conflicting testimony also about whether the driver was on his phone or was not on his phone. Is that correct? He claimed he was not, the pedestrian claimed that he was.
Yes, that's correct. And then our position is that the judge did what she was supposed to do, weigh the credibility of the witnesses, and she came to the conclusion that obviously he was on his phone and not paying attention if this incident occurred in the first place.
Did the judge make a direct credibility finding, or are you just saying that was an implied credibility finding because she chose one person's testimony over the other?
Well, in her ruling, she says that she weighed the credibility of Mr. Haney over Mrs. Easley. Like, that's in her ruling, that she weighed the credibility and found that it was more probable than not that Ms. Easley's testimony was the way the accident occurred.
Thank you.
Is there any dispute about the fact that the accident occurred immediately when your client stepped into the street?
I would say there's no dispute about that. She's admitted when she stepped off the curb, she was knocked to the pavement at that time. Immediately. There's no dispute about that. But again, as far as negligence per se, violating this, the appellant's argument is that plaintiff violated this ordinance that she's supposed to yield to motorists if she's not walking in a crosswalk, and that if she violates that statute and admits to violating it, that equates to 50% or more at fault. And there's just no case law on that. Again, the judge is able to determine allocation of fault. That's the whole point of the comparative fault statute. If the plaintiff's negligence is less than the defendant's negligence, it should not bar plaintiff recovery. And again, as far as admission of guilt here, there was some testimony that she may have admitted that she was not in the crosswalk and pled guilty, but there's been no documentation or proof of that guilty plea.
There's a question about that?
Sir?
Are you saying there's a question about that?
No question about that, but there's no question about it, but as far as any documentation or proof of her going in open court and saying, hey, I plead guilty, we don't have that, Your Honor.
I'm not asking that.
Yeah.
I'm just asking, is there a question about
No, again,
all we've been talking about here?
no, again,
During
she's
this argument?
admitted that she was not in a crosswalk. That there's no question to that. It's just that just because she was not in the crosswalk does not mean that she was, more than the 10% at fault.
So she admitted that she pled guilty to the charge, whatever charge that she received for not being in the crosswalk. She did, there's not an issue about that. Your client admitted that, correct?
Through her testimony, yes. And I believe my time is up. I believe it says stop.
But you can answer a question.
Okay, yeah, there's no question about that. She did.
Thank you.
Thank you.
Thank you.
Many of the things I thought I would be covering were covered just in the last 5 minutes, so I'll be brief.
Nobody's ever brief after they say, I'll be brief here.
I realize that, so I'm going to plead guilty to that. I'm going to try and be brief.
Okay.
The ordinance 1128-4 says a pedestrian shall not cross at any place except in a marked crosswalk. And if they do, shall, again, yield the right-of-way to all vehicles upon the roadway. That's the ordinance that she pled guilty to. But the one thing I want to impress upon this court more than anything...
When you say she pled guilty to, is that in the record?
It is in the record. She admitted it multiple times. In court, didn't just send the check in, went to court, admission, judicial, or her admission. It's not a big deal about negligent hiring or retention. Well, let me just say that it very much is. For the city of Memphis, it's got strict standards. Paul Haney's a 10-year now employee, and not one detrimental bit of evidence was offered at trial other than this alleged cell phone use, which was denied, but the court found, and so be it, that is what it is. But there's no proof of negligent hiring, no proof of negligent retention. The court relied upon that in her damage award. I believe the more convincing effect of the preponderance of evidence supports a finding contrary to what this court awarded in all aspects: amount of damages, amount of fault, proximate cause, in every shape, form, and fashion. That said, now, are there any questions? I'd be glad to answer anything. I was brief.
You were brief.
Thank you for hearing us.
I stand corrected. Thank you. Thank you, counsel. We will take this matter under advisement and review the record and attempt to get an opinion at the earliest possible time.
Thank you.
Thank you. You may be excused.